Lordship, I like to make a mention of item number 7, Lordship. Some difficulties today, Lordship. If it can be on next Monday, Lordship. I've taken the
I'm for the
consent of-
appellate. I'm for the appellate.
Just come for orders.
Lordship.
What order?
Lordship,
Otherwise, I have filed this appeal against an order rejecting my bail prayer.
I find my
Prepare paper which I'll-
So we'll fix it for hearing then.
Hearing, madam.
You wait when the matter is called. Send your junior.
Lordship.
I have taken concern my friend, my lord. In respect to item 9, my lord.
Yes.
It's IA for bail, my lord, may pray. I could not prepare it, my lord, after 2 weeks, my lord. To be fair, my lord.
Mr. A.K. Hussain, learned counsel for the applicant, prays for adjournment. Consideration of the bail application on the ground that he could not prepare the matter.
Duty.
This court, full stop. Since the prayer is made with the consent of the learned APP Assam, same stands allowed. This matter stands adjourned for 2 weeks. Hello.
Daily list for admission, item 1.
Item 1, your lordship, I have filed my objection, but I was supposed to get the instruction as to whether respondent number 2 was served or not. Notices have gone. I spoke to the Sibsagar OC, but I'm yet to get the instruction. 1 or 2 days, if your lordships gives me time, I'll get the instruction. It's a POXO matter again
Posted
because,
on Friday then.
lordship, Friday
Mr. A.
posted.
Goyal, learned counsel for the appellant, also heard Ms. S. Jahan, Deputy Assam, appearing for the state, who submit that instructions as directed by this court has been called for from the concerned officer in charge of the police station. And therefore, but the same is yet to be received. S. Jahan seeks posting of this matter again on Friday. Give the date of Friday.
Yes,
11/11/2020.
positive.
Deeply.
May I please, your lordship. This appeal is preferred against conviction under section 4 of POSCO Act, lordship. Convicting him to suffer for 20 years and with fine of 1 lakh, my lord. So my prayer is to admit this appeal, my lord, and call for the LCR, my lord.
This is statutory appeal
Lordship, yes.
to be admitted.
Yes.
Statutory appeal. Heard Mr. D. Bora, learned counsel appearing for the appellate. Also heard Ms. S. Jahan, learned APP Assam, representing the state. This appeal against conviction is directed against the judgment and order dated 2022, passed by the learned special judge, Bongaigaon. The bracket close. Case number 31, bracket M. Section 4 of the and sentencing him to undergo rigorous imprisonment for 20 years. This 1 lakh default stipulation. We have finished the grounds taken in the memo of the stop, admit the appeal. Issue notice returnable in 6 weeks. Only 1 respondent.
Yes, lord. Yes, lord.
Yes.
S. Jahan, learned APP Assam, has appeared and accepted notice on behalf of the state.
We also file an IR, my lord, for bail.
No formal notice is required to be sent to state respondents. Steps for submission, for service of notice upon the respondent number 2 by registered post with AD within a period of 1 week from today. Where is the IA?
I is for bail,
Then
my
you
lord.
write call for the LCR.
It may be taken after the receipt of LCR, my.
You write so and so for applicant, so and so for state,
Will file objection.
prepare for that after receipt of LCR. The state may in the meantime file objection if so requested.
Lordship.
Obviously.
Item 3.
May please, your lordship.
Yes.
Well, the appellant is sentenced to undergo rigorous imprisonment for 22 years, my lord, and fine of rupees 50,000 under section 376(3), my lord, of IPC by the my lord, Special Judge Bongaigaon.
All right, same here, we have to admit it. Heard Mr. N. Uddin, learned counsel for the applicant, appellant. Heard Ms. S. Jahan, learned FPP Assam, representing the state. This appeal is directed against the judgment and order dated 8/9/2022. In connection with special bracket this is bracket BGN close of 2020, whereby the sole appellant has been convicted under section 376 bracket P, read with section 4 of the POCSO Act, undergo imprisonment for 22 years. Also, to pay fine of rupees 50,000, in default to undergo simple imprisonment for further 1 year. We have perused the grounds taken in the memo of appeal, admit the appeal, issue notice returnable in 6 weeks, since Ms. S. Jahan, learned FPP Assam, appeared and accepted notice on behalf of the state. This is required to be sent in this case.
Respondent number 2 is not here. The victim is not made a party
Victim is
here.
not made a party, so.
But 376, that
It is up to
victim,
him, we can't say anything.
I may be allowed to,
That you
And-
give an application.
by hand may be allowed.
Yes, so. Call for the record, you given. Let this matter be listed after receipt of LC. You make an application. We'll see.
Obviously.
Item 4.
May I please, your lordship? Your lordship, appeal against judgment and order dated 27/9/22, your lordship, wherein the accused was, your lordship, then for 20 years, your lordship.
This is also POCSO. Same order, Mr. Espal put the dates, etc. And she had 6 weeks. Steps on respond number 2.
there are two
Two
respondents.
responses, your victim in
Carry
court.
for one.
I'm for 1, 2 and 3, there are two respondents.
2 and 3.
2 is informant and 3 is victim. There is an IA, your lordship.
Yeah, I is so and so, so and so, so and so, so and so. The prayer for bail made in this IA shall be considered after the receipt of LCL. The state may, in the meantime, file objection. Statement, the respondents may in the meantime file objection. If so advised. You make notice returnable in 6 weeks. So yes, take steps on OP numbers 2 and 3. And the first matter also, the notice.
Obliged, your lordship.
Item 5.
Council is not there. Again, RI for 20 years, POCSO.
Pass over for the time being. So in bail matters, 6 weeks is a long time. We'll make it,
Yes.
how much? 2
Three-
weeks.
2 weeks.
So in the IAs, you make it 2 weeks, both the cases.
Item 6.
May I please, your lordship? Lordship, I am appearing as a legal aid counsel in this matter. Lordship, steps have been taken around respond number 2 through the registry, lordship, and this in this matter, the report was called for. from
It's
the
got
Gulab-
POCSO matter. It's a
Lordship,
POCSO matter.
yes, lordship,
Notice has to be served.
lordship. But a direction was given to the registry to send a letter to the Golaghat State District Legal Services Authority to inform whether the respond number 2 is interested in pursuing the matter and appearing in the court. From the last office note, it appears the copy has been sent.
Report Ahmed.
Respondent number 2 is the mother. Lordship will find the orders in the last order of this honorable court, Lordship. On 27/7/2022 or thereafter, the last order passed by this honorable court, it is reflected, a copy has been sent. Whether the informant is to be instructed, whether she wants to appoint a counsel from the legal aid.
No, but has the appeal been admitted?
Yes,
By which
appeal has
order?
been admitted, Lordship.
LCR has not yet come. LCR has-
LCR has been
It's here.
received from the causelist, it appears that LCR has been received.
Let the paperwork be prepared.
Yes, Lordship.
Heard Mr. H. Chaudhary, learned legal aid counsel appearing for the appellate. Ms. S. Jahan, learned APP Assam appearing for this state stroke respondent number 1. Post of peruse the order dated 26/9/2022. Post of, it appears that court's order 26/9/2022 has been furnished to the member secretary. Legal service authority for bring the needful post of however. Is not reflected. Lordship registered to therefore obtain feedback to the how can member secretary, is he a party here?
No, your Lordship.
No, Lordship is only that note. He
Notice
will
is to
serve
be
the
served.
notice on the,
Yes. Like the
As per the
registry
court's
serves
order.
the notice upon on the same way it was directed that the registry should take that. Member secretary was directed. And whether she wants to engage a legal counsel or not.
we can await the report. Member secretary will definitely send
However,
it.
report from member secretary Asad sir is still awaited. Be that as it may, since the LCR has been received, ministry to take step for preparation of paperwork. Let the matter be listed again after 4 weeks. We have to pay the-
Obliged.
Item 7.
Although the pleadings are complete, your Lordship may wish to take up the matter for hearing in the next week. For hearing in the next week.
Why this appeal has been listed? today? The Prasad, why this has been listed today?
I couldn't see the file to the morning one.
Why this case has been listed today?
It has come in the orders.
Both sides, this matter stands adjourned for 8 weeks. There is nothing in the. This no-
Lordship may fix for hearing.
Hearing LCR has come.
LCR is not required, my lord. It's against an order rejecting the prayer, my lord.
But case diary will be required.
Lordship, there
They
is a
can
office
produce it.
note.
madam. They
You
can
got the
produce it.
case diary.
Not today, Lordship.
So say something. You are saying nothing.
So Lordship,
Then
by
we'll take
next
up the
week.
matter. We'll note
So
that.
case diary has.
You have not made that request in the beginning. You are not giving any answer when we are asking you.
No, Lordship, case diary is not with us today.
Hmm.
So we may produce by the next week. Next week, Lordship.
Council appearing for the respondents to place for and is granted 10 days further time to produce the case diary. Let the matter be listed accordingly.
Obliged, Lordship.
Item 8.
My objection is on record, the I.
Your Honor, I have received the objection, Your Honor, today, Your Honor.
Hmm.
So we have received the objection, Your Honor, today, Your Honor. So I pray for time, 2 weeks time may be granted, my lord.
You want bail and you are asking for time.
Yes, we have received the copy of the objection today, your honor.
But it was filed long back. Oh, acha, acha.
Clerk of Takas.
Oh, it was with the clerk. Otherwise, I filed it long back.
Don't understand how the bail applicant's client is asking for time. Very sad. What is your name?
D. Sharma, Dipen Sharma.
Mr. D. Sharma, learned counsel for the applicant submits that filed on behalf of the state in this case has been served upon him only this morning. On such ground, the applicant's counsel has prayed for posting this matter again after a week. Prayer allowed, Ms. S. Jahan, learned deputy Assam is present on behalf of the state, registering this case accordingly.
Oblige.
Item 10.
May I please lordship. My lord, we are for bail today. The notice of our private respondent, that is the complainant, has been already served. Lordship may kindly see the office note dated 27/9/22. So, my lord, this is actually a case of moral conviction, my lord. It is not established on the basis of the statements of witnesses. For a moment, my lord, I do your lordship's kind understand. Kindly see page 128.
Some objection can reduce, number of objection can reduce.
Page 128. May I read my lord 128? In view of the above circumstances, I would like to list the following mitigating circumstances in favor of the accused persons convicts. The entire case is based upon indirect or circumstantial evidence. 2. The accused Srimati Lal Bhanu has 3 children to look after. The accused Khandakar Shafur Rahman also has a family consisting of his wife and children. The offense was committed probably due to extreme emotion of love or hatred. So, my lord, if your lordship kindly have a look to the witnesses, altogether 34 witnesses.
What is this? This conviction is under which section?
302.
302.
Yes.
Based on circumstantial evidence.
Yeah, only circumstantial evidence, my lord. And no witness said that I have committed. And second
Means
thing,
no eyewitness.
circumstantial evidence, my lord, lordship is aware about this. The circumstances witness must point out to the guilty of the accused without any shadow of doubt. Now here, my lord, it is said the Bijli police station and Bijli court hardly 100 meter away. There was no 164 statement. Only the accused due to threat and third degree method, he at conference before police that I have murdered. But surprisingly, my lord, the investigating officer never sent him for recording his statement. One person was killed by police encounter, where there is on record I will show 50 police personnel were there. And one that Abdul Khalek, my lord, they say that Abdul Khalek tried to snatch the pistol of SDPO Bijli. Is it possible? Then he was killed. I am not Abdul Khalek. So this Abdul Khalek was killed because he perhaps, I am not against him, he has been killed and he may be the prime accused. Now, my lord, moral conviction is not the way, it is the allegation of the prosecution that this Shafur Rahman, who is the sole appellant here, has some relations with Lal Bhanu, who is the wife of deceased. Now, that is a doubt, my lord. For a moment, if your lordship kindly permit me, the witnesses of the persons, for a moment, my lord, I will satisfy your lordship that this is not a case of conviction at all. From the kindly see, my lord, the witness of PW1, Shamsul Ali. He kindly say, he said, I am informant that this is Yad Ali was my younger brother.
Page number.
In the that I have no direction. It is on record, man. I'll share. but we have annexed only judgment and order. LCR is,
Yeah, we have not received. It's not shown in the list.
then, my lord, I have got some copies. If your lordship kindly permit me, may I read the relevant portion? He is the main person. He says, I doubt the accused Khandakar Suburaman has illicit relation with the accused Lalbanu, who is the wife of deceased brother, and so I doubt. My lord, doubt and suspicion cannot be the substituted proof. There are so many judgments. Now, this is the Vitalu one, my lord. Now,
There is an order of 28/9/2022 passed by this court. Where the court after hearing has said that perusal of the record will be necessary. So accordingly, additional sessions at Shirang may should the record to be sent on the next day.
two
What is
times,
absent?
2 times it was ordered, but
Have you seen that order?
yes, I have seen. But the thing is, this since last 2 days, the records are not coming on. And the person is in custody since the day of filing the case, that is on 5/8/22.
Right, we'll post it on Monday and get the soft copy positively, coming Monday. 14th of November.
Oh, like.
Chairman Mahmood Lani concept of the applicant also admitted the exam and he has to be carrying for the state. Perus be ordered 28/9/2022 by means of LCR was by this court for consideration of this IA as per office note dated 11/10/2022. The order of this court has also been duly communicated. Additional session judge, Chirag, Digni. However, the LCR is not available. Full stop. The registry to therefore not available. Stop. The applicant, on the other hand, is pressing for an order on his bail application. Gently stop. In view of the above, registry to look into the matter. Find us, LCR, and if necessary, in the scanned copy of the LCR on or before the next date fixed. Use this case again on. We'll put it on 16 because Monday they may get the record. 16.
On that day, bail may kindly be considered on that day.
Yes, yes. 16/11/2022 as a fixed item.
Not.
Oh, that's good.
Lordship, in item number 11, I was directed to obtain instruction from the jail authorities whether the petition, this appellant was given any treatment, your lordship. I have received the reports, lordship, it's on record. I have given the copies to them. Page 6 is the report from the jail authorities. 6. He was given treatment in the Name Care Hospital as well as in the Sankardev Netralayam, I know. And he was given necessary diabetic lordship supplement in the jail as per order of this honorable court. Name Care Hospital, private,
So what is the, you have seen this?
Yes, Miss Lordship. After I surrender before the jail authority Lordship, I'm not get any treatment before Namcare Hospital Lordship. I only
What is the element of your client?
yes, Lordship.
Lordship recollects in this case on the plea of Lordship, he's having kidney ailment as well as he's diabetic. Number of occasions he was released on bail. The last occasion, dishonorable court on 14/9/2021, and thereafter, your Lordship, since the doctors have advised that the condition of the appellant is stable, your Lordship directed him to my lord, surrender before the jail. Now again they have come up with a plea that he is not well, but he is regularly given treatment by the jail authorities, and whenever it is required, he was referred to Guwahati.
So he has been sent to Sankadev Netralaya, then to GMC.
Yes, Lordship, but he was as per the last order, Lordship, 22/9/22, Lordship, kindly page the order 22/9/22, Lordship. As per the last order, Lordship, he was supposed to get special treatment even outside jail, Lordship, but he has not got such treatment. He was only taken to Sankadev Netralaya, Lordship. But he was not taken to any cardiologist, diabetic doctor, or neuro doctor, Lordship.
So GMCH, which was the department which was he was referred to?
Nephrology is a kidney patient.
How do we know what is his health condition?
Lordship, on the last occasion, they said he's stable, my lord. Because,
No.
Yes.
We would like to see it.
yes, Lordship, prescription is there, backside at page 7. Page 7, Udalguri Civil Hospital. It is up to 26/9/2022. A case of type 2 diabetes mellitus, hypertension. So and so.
So he was sent to the GMCH.
He was in name care as per they said, Lordship, if I remember it correctly, they said he needs special treatment.
Yeah,
My lord,
let's put that.
my
there
lord,
for the time.
my lord.
According to this report, he was sent to Netralaya
Yes,
and also to the GMCH.
yes.
Correct?
JMCH, yes, my lord.
Yes.
Yes.
Where are the prescriptions? So in page 6, it seems. that
Yes, my
the
lord.
doctor has referred him to Nemcare Hospital.
Yes.
Then why he was not taken to Nemcare Hospital?
Down below it's written, my lord, as there is no facility so and so, refer to Sankardev and name care. Lordship, he may be given treatment here. What is required, wherever it is required. And the Lordship WhatsApp message there, page 2, my lord, of 31/10/2022. As per advice, he was sent to GMCH, Guwahati and Sankardev Netralaya for treatment. However, he was not sent to name care as attending doctors have not referred him to name care hospital. He went to name care hospital privately while he was on bail.
No, but
Yes.
that is not consistent with the jail doctor sends him to
My
Nemcare.
lord,
And then the jailer has some other view.
my
He cannot sit in appeal over
my
the
lord,
medical.
my lord,
We'll just adjourn it.
my lord.
Maybe the jailer to come and explain it. Because if the doctor says he should be taken to Nemcare,
Yes,
then there should be good reason for not doing it, or it should be done that. They are also not medical experts.
My lord.
Nor is the jailer.
Lordship.
There is a scope of revisiting this at the court level.
Lordship, Lordship may direct as per advice, as per requirement, he may be treated wherever within the jurisdiction of this honorable court. Today only I'll inform them.
After 2 weeks. It's,
Lordship.
in the meantime, do it. You see, if we have to write something,
Yes,
maybe pretty adverse.
my lord.
So the jailer better understand.
Lordship,
this.
lordship.
Because the jail doctor is saying he should be sent to. next
Yes.
year. Whatever be the reason. Let him go there, have him checked up and give us the report.
Yes,
That's how we proceed in
My
these
lord.
matters. Heard Miss N. K. Malakar, is it?
Yes, Lordship.
Senate Counsel for the applicant who submits that despite the order dated 27/10/2022, the petitioner has not been sent to Nemcare Hospital at Guwahati for better treatment. Miss B. Bhuya learned APP Assam has however produced pictures of some WhatsApp within Kodo, WhatsApp communication herself and the assistant jailer Udalguri, according to which the applicant was sent to Sankardev Netralaya, but not to the Nemcare hospital. We, however, find that by that on 29/10/2022, the medical and health officer -1, district jail hospital, Udalguri had himself referred the applicant for treatment Nemcare Hospital, Guwahati. Under the circumstances, it is not understood as to why, despite the order of this court, the petitioner has not been provided with the facility of treatment at Nemcare Hospital. Since Ms. Bhuya has paid for 2 weeks time to do the needful, we adjourn the matter till 18th of November, 18/11/2022. So as to enable her to updated instruction,
today only I'll inform them.
place the same before the court along with the medical report. This case accordingly.
Lordship, kindly on 17, Lordship. On 17, Lordship.
You want it on 17?
Yes, Lordship.
17 ki bar?
17.
17.
Oha festival, no?
All right, 17, she may have some.
My
difference.
lord.
17.
Mass of license.
You tell him why they are
Yes, yes.
complicating things.
Yes,
It is
yes.
not his personal
My
matter.
lord.
You don't know, medical matters are very.
Lordship,
sensitive.
lordship.
Let him have his treatment.
My lord.
Mass of license.
और तो लिखे बोले।
May I please, Roshan? There is a delay of 15 days in filing the appeal under section 302 for life.
We'll condone it.
Condemn, lordship, may please.
Mr. D. Talukdar, learned counsel for the applicant, also heard Ms. B. Bhuya, learned FPP Assam, again on in this case on behalf of the state. This IA has been filed under section 5 of the limitation grant from 1963 to condone the delay of 15 days in filing the connected appeal system. We have perused the grounds taken in the IA and also heard the submissions advanced by learned counsel to the side. Ms. Bhuya submits that she has no instruction. Her junior has no instructions to file any objection opposing the prayer in this IA custom. The connected appeal has been preferred against the judgment and order of conviction under section 302/34 of the IPC, and considering the explanation furnished in the IA, we are inclined to condone the delay. As such, the delay of 15 days in preferring the connected appeal is hereby condoned. Office to register the appeal and list the matter for admission. IA stands dispaper.
Item 13.
May please, Lordship. But the IA is for consideration of delay of 31 days, in preparing the appeal.
31 days.
31.
Will be condone?
Huh?
Maybe condemned.
Yes, Mr. K M Haloi.
I am appearing
Which
as legal aid
section,
counsel.
which section is involved?
302.
302, 34 to navigate. Baki rakhe ho.
In this case, I am appearing as legal aid counsel.
Mr. K M Haloi, legal aid counsel.
Much better.
Currently, matter item 5.
Sorry, my lord, I could not appear in time, your lordship.
This matter,
This is against conviction, your lordship. Convicted under section.
there is conviction.
9. Under section 6 of POCSO Act, convicted.
Will admit the.
Not sure.
Admit Goldman? Heard Mr. A. Rahman, Learned Counsel. A. Rahman, Learned
Yeah.
Counsel for the appellant, also heard Ms. S. Jahan, Learned Association, the appeal for the state. So this appeal is directed against the judgment dated 26/9/2022, passed by the Lanis Special Judge, Bongaigaon. Special bracket C, bracket close, case number. P, case number. 1 bracket BGN bracket close, stroke 2022. The sole appellant has been convicted under section 6 of the POCSO Act and sentenced to undergo rigorous imprisonment for 20 years to pay fine of rupees 50,000 with default stipulation. Full stop. We have perused the grounds taken in the memo of appeal. Heard submissions advanced by learned counsel for both sides as to admit the appeal, call for the records, issue notice returnable in 6 weeks. Since Ms. Jahan has appeared and accepted notice for the sole.
There are two respondents.
Respondent number 1.
Sahara is the victim. Actually, the victim name should not be given. But then
Hearing list, additional hearing list, special legal remedy. Item 1, 2, 3, 4 and 5, 6.
Amicus motion.
Item 6.
Madam.
Item, you are appearing in item 6.
6. Join all the time.
Mr. Decker. What's the matter about?
302 conviction, my lord. FIR lodged by the brother of the deceased, my lord. Allegation is that the husband killed the wife, my lord. The FIR says that she was assaulted with a dowel. She received previous injuries. 2 days later, she succumbed in the hospital. The prime witness is the daughter, my lord, PW2. On the previous night of the incident, there was a marriage in the house, marriage of the son. And she says that she was sleeping in the same bedroom. She was sleeping on the floor. The parents were sleeping on the bed. At around 4 o'clock at night, she went outside to answer nature's call. When she came back, she saw the petitioner, appellant, madam, that she was running away from the house. Then she came inside the room and she saw the mother was lying in a pool of blood with injuries on the head. Immediately, she called her brother. They took her to the hospital. 2 days later, she succumbed.
What is the time of the incident?
At 4 o'clock at night, madam. In the morning, madam, 4 a.m.
And the appellant was not found at home.
Appellant was not found at in the home.
What is his explanation?
That is the difficulty, but 313, he does not give any explanation, madam. It's a case of simple denial. Because there are probabilities, madam, because it could be that someone has entered because there was a marriage on the other night. Some thieves had entered, assaulted, he ran after the thieves, madam, but unfortunately in the 313, he does not say anything.
Let us see the Jahan. Ms. Bhuya, you are appearing?
Page 4 is the FIR, my lord. Most respectfully, I beg to submit that at around 4 o'clock in the morning today, that is 22nd of September 2016, the husband of my elder sister wounded her grievously without any reason by dealing cut blows at two or three places over her head with a dowel. Upon learning about the incident, we got her admitted to Dhupli Civil Hospital. At present, her condition is not good. You are therefore prayed to take necessary steps for investigating into the matter and all. She succumbed on the 24th, my lord. Thereafter, 302 was added at page 5, my lord. Charge was explained, my lord. PW1 starts at page 8, my lord. He is the son, my lord.
Yes.
The accused journal so-and-so is the husband of my, I am not the son, my lord. He is the informant. The accused journal Bepari is the husband of my elder sister Taraban. On the date of the alleged incident at about 6 a.m., I came to know that the accused had severely beaten up my elder sister, so-and-so, and her son Mohammed had shifted her to the Dhubri Civil Hospital. Then I went to the civil hospital and found my elder sister there in injured condition. She was not in a position to talk. The son of my elder sister, namely Nur Mohammed, told me that the accused had assaulted her and caused the said injuries. So his evidence is basically, my lord, in my respectful submission is hearsay, my lord. Then I lodged the FIR of the case with the police. Exhibit 1 is the FIR and Exhibit 1 is my entire signature. The doctors of the Dhubri Civil Hospital told us to shift so-and-so to Guwahati, and we shifted her to the GMCH. After 2 days, Tarabanu succumbed to the injuries at the GMCH. I did not write the FIR. I cannot say what is written in the FIR. About 20 years ago, the marriage of Tarabanu was solemnized with the accused. They have 5 children. On the day of the occurrence, the marriage of the second son of the accused was solemnized, and thereafter the incident occurred. It is not a fact that I did not tell the police about that. Nur Mohammed told me that the accused assaulted Tarabanu. The distance between my house and the house of the accused is about 1 kilometer. It is not a fact that the accused did not assault Tarabanu. Then PW2 is the son, my lord. The accused so-and-so is my father, and the deceased Tarabanu was my mother. About 9-10 months ago, one day at about 5 a.m., my elder sister called me and told me that my father had killed my mother and fled away. Then I went to the bed of my mother and found her lying in a pool of blood. I put a gamucha in the wound on the head of my mother and took her to Dhubri Civil Hospital. The doctors of the hospital told us to shift my mother to the GMCH, and we shifted my mother to the GMCH. After 1-2 nights, my mother succumbed to the injuries. At the time of the incident, I was sleeping in my room. It is not a fact that I did not tell the police that my sister told me that my father had killed my mother and had fled away. It is not a fact that this is a suggestion that it is at the instance of the informant. Now, PW3 is the main witness fellow. The accused Joynal Bepari is my father, and the deceased Tarabanu was my mother. I stay in my parental house. On the date of the alleged occurrence in the morning, I went to the backyard of our house to attend nature's call. And when I came back, I heard a noise and saw that my father was running away from the house. Then I entered into the house and saw my mother lying with injuries in the head in her bed. Then I called my brother Nur Mohammed and told him that my father had killed my mother. At that time, no other persons were present in our house. My brother Nur Mohammed took my mother to the hospital. Later on, my mother succumbed to the injuries in body. Cross-examination. On the day of the occurrence, I was sleeping in the room of my parents on the floor, and my parents were sleeping in their bed. It is not a fact that on the day of occurrence, my father was not present in the house and he did not kill my mother. It is not a fact that I did not tell the police that I saw my father running away from the room of my mother. It is not a fact that I did not see my father running away from the room of my mother. It is not a fact that my father has no connection with the injuries sustained by my mother, and I have deposed falsely against my father. Now, Lordship may skip the next witness, my lord. Then Sadadat Ali, my lord, he's a neighbor, PW5. I know the accused. He was the husband of my deceased neighbor. This is the deceased sister, the sister-in-law. Sorry, brother-in-law. The house of the accused is adjacent to my house. On the day of the alleged occurrence at around 5 p.m., my lord, I think this should have been AM. Daughter of the accused, namely Jai Bhanu, came to my house and told me that the accused has murdered Tara Bhanu. Then I went to the house of the accused and saw bleeding wound on her head. She was lying unconscious. We immediately shifted her to Dhubri Civil Hospital. From Dhubri, we shifted her to the Guwahati Medical College. During treatment, after 2 days, she succumbed to the injuries at the GMCH. On the previous day, there was a marriage ceremony in the house of the accused. It is not a fact that I did not tell the police that the daughter of the accused, namely so-and-so, came to my house and told me that the accused has murdered Tara. Before the incident, we all wanted the accused to live in a different place with his family. It is not a fact that the accused did not murder so-and-so, and we have falsely implicated the accused in this case. Now, this is the IO, PW6. On 22nd September 2016, I was posted at the Dhubri Sadar Police Station as an ASI. On that day, the OC in the Dhubri Sadar Police Station entrusted me to investigate this case. Accordingly, I investigated the case. During the course of investigation, I found that the victim was shifted to the Dhubri Civil Hospital, and hence I went to the Dhubri Civil Hospital and recorded statements of some witnesses. As the condition of the victim was critical, she was shifted to the GMCH. After 2 days, the victim succumbed to the injuries. I visited the place of occurrence and recorded statements of the remaining witnesses and arrested the accused and forwarded him to the court. Later on, I collected the post-mortem report. After completion of investigation finding sufficient evidentiary materials against the accused, I submitted the charge sheet for offences under 302, 341 IPC against him. Exhibit 2 is the charge sheet and Exhibit 2.1 is my signature therein. Exhibit 6 is the post-mortem report that I collected from the Guwahati Medical College. I arrested the accused on the day of the occurrence itself. The accused had 2 houses. On the previous day, there was a marriage ceremony in the house of the accused. It is not a fact that being the ASI, so-and-so, this is not important. Exhibit 3 is not prepared in my presence. Then comes the evidence of the doctor, madam. Evidence of on 24/9/2016, I was posted in the Department of Forensic Medicine, Guwahati Medical College and Hospital as assistant professor. On that day, the so-and-so conducted post-mortem examination on the dead body of one Tara Bhanu, aged about 45 years, wife of Jainal Bepari, who is escorted and identified by homeguard so-and-so, which was concurred by me. The following observations were recorded. A female dead body of average build and dark brown in complexion is found wearing blue blouse so-and-so, so-and-so, so-and-so. Dried blood stain was seen on face. Intravascular cannula in situ was present over right ankle joint area. Body is warm. Rigor mortis was present in upper lips and partially present over lower limbs, external genitally healthy. Following injuries were found on the head. Surgically stitched wound was present on the left side of the face, repaired with 10 numbers of stitches, starting 3 centimeter lateral to the left eyebrow and directed anteriorly towards left cheek. On removal of stitches, lacerated wound with irregular margins of size 8 centimeter by 0.5 centimeter into muscle deep was present and area was contused. A surgically stitched wound was present over left temporal area of scalp, 3 centimeter over left ear, repaired with 3 number of stitches. On removal of stitches, lacerated wound size of 5 centimeter by 0.5 centimeter into scalp tip is present with irregular and contused margin. A surgically stitched wound was present, 4 centimeter medical to injury number 2, and repaired with 3 number of stitches. On removal of stitches, lacerated wound size so-and-so is present with irregular and contused margins. No ligature mark is detected around the neck. On dissection neck tissues are found healthy. Scalp contusion present over left frontal, temporal, and postparental area of skull. Comminuted and depressed fracture is present over left temporal area of skull, size so-and-so, membrane so-and-so. The opinion is that the death was due to coma as a result of injuries sustained over the head. All the injuries were antemortem and caused by blunt force impact. Lordship will keep a note, my lord. In the FIR, it is said it is done with a dowel, my lord. But the postmortem says that it is a blunt force impact. Approximate time since death is 2 to 6 hours. Exhibit 3 so-and-so. The deceased was cross-examination. The deceased was treated somewhere else. The postmortem was done in my presence by Dr. So-and-so, who was a PG student. in the report, it was not mentioned that the extradural hemorrhage was primary or secondary. Bruises are superficial injuries. The inquest was not done in my presence. It is not a fact that Dr. So-and-so did not put his signature in the postmortem examination report in my presence. In the postmortem report, the dimension of the force is not mentioned.
The weapon has been recovered.
No, nothing is recovered. And Lordship sees the 313 statement, my lord. Everything is case of denial, my lord. Whatever is put to him, he does not offer any explanation. That is where I'm finding it difficult, my lord, because because this is a case of, ultimately, it's a case of circumstantial evidence. There is a possibility that at night when the daughter went out, someone might have entered, because it is very improbable that she went out. It is a matter of 15-20 minutes, maximum half an hour. Now, what transpired between that period that he assaulted and killed his wife in the middle of the night?
You can argue that if a case is projected on that behalf, was there any, forget the accused, was
Ma'am.
there any cross-examination on that?
Only the suggestions Lordship has seen.
Where is the suggestion that somebody else is? entered?
No, there is no suggestion.
Then can you argue that?
That is the difficulty. Because had there even been a suggestion,
Accused is silent,
accused is silent.
then also at least that case ought to have been projected during the
Exactly.
cross. There is no such attempt.
Nothing.
So.
I'll draw your,
Trials can be.
I'll draw your Lordship's attention to one paragraph of a judgment, my lord, that Lordship knows, my lord. They come from our High Court, the Rima Hazarika's case. In paragraph 10, it was observed that trial was conducted by a legal aid counsel. Here also, it's the same thing, my lord. Though Supreme Court said that though we are not making any observations on that, but he was denied with an opportunity. Here also, my lord, I think, my lord, some line of cross-examination ought to have been there. Because had there been one sentence in the 313 statement that I ran after someone, because this story is highly
That's
improbable.
correct, but the idea of criminal trial. is
I
not to-
understand. I understand.
Not to accuse the accused by hook and by crook.
Exactly.
By hook or by crook. That is not the whole idea.
But the chain of events, my lord, somehow, what transpired in those 10-15 minutes in the middle of the night, you get up from your sleep and you assault your wife.
That's it. You see, if there was really, if it is really a case where somebody else entered, this would have been there in the lower court proceeding. Nobody has made any such whisper.
No,
So now, in the appellate stage, can you project a new story?
my lord,
Can you project a new story at the appellate?
difficult, my lord, the definite stage.
Otherwise, what is the doubt here? The incident happened inside the house.
Is it a 106?
Daughter says, saw the father running away. She's remained intact. She could not be, her evidence could not be breached.
And no evidence has also come in, my lord, that there was some discord between the daughter and the son, daughter and the father. That they have deliberately, because it is highly unlikely that the son and daughter will say something. But the investigating agency, my lord, I also think, because they ought to have investigated that line, that was there any, because there may not be any break-in, my lord, because admittedly she had gone out. She might have left the door open. We do not know what has actually happened. But the lordship sees the IOs, my lord, he has done nothing. He has gone there, recorded the statements and filed the charge sheet, arrested him.
They don't have time for this thing. It's his greatness that he could at least file a charge sheet. They are busy in something else. Koila, truck, these are more important. Anyway, we will go by what is on record and what is legally
Lordship.
permissible, because there is no other option.
313 was some, at least he should have said something. Maybe he thought that he will be required to prove it, madam. Because what he is required to establish, the accused is required to establish by preponderance of probability, a doubt is to be created. That someone had entered, assaulted, Because there is every likelihood, lordship is absolutely correct, and there is not even a suggestion to that effect. But there is likelihood, my lord. Because at the middle of the night, you wake up.
In a case of similar nature, I have authored a judgment division bench. I think Chamua was, AC Chamua was the,
Then my learned friend appeared. Yes.
there, the court has given the benefit of doubt and acquitted.
My lord.
But then there was a story projected there.
Exactly.
In the 313 also, the accused had said something.
Even that in that 2019 13 SCC 289, my lord, that Rima Hazarika's case, there also, my lord, in the 313, she had stated. She was convicted by the High Court, my lord, it was
Rina
Rina Hazarika, my lord. Rina Hazarika. The husband had died, the wife was
says that 2013,
2019 13 SCC 289, my lord.
this is Ravindra Nariman's.
Nariman. No,
There it has been said that if the accused offers an explanation.
exactly.
The court has to deal with it.
And there an explanation was offered. The wife had stated something, my lord.
And here in this case, circumstances were put to him, my lord, the accused
Circumstances were put to him, he simply denied.
denied.
I'll draw your lordship's attention to that question, my lord. Question number 4 in the 313.
Question number 4.
4. Because ultimately what the son says and the others say, my lord, it is all from the daughter. PW3 so-and-so has deposed that the deceased so-and-so was her mother. She stays in her parental home. On the day of the alleged occurrence in the morning, she went to the backyard of their house to attend nature's call. And when she came back, she heard a noise and saw you that you were running away from the house. She then entered into the house and saw the deceased lying with head injuries in her head. She then called her brother so-and-so and told him that you had killed her mother. Her brother took her mother to the hospital and returned so-and-so, so-and-so. She has deposed falsely. I did not kill the deceased. Had he given some explanation here?
That we have followed. Explanation would have definitely given it a twist. But even without explanation, the defense counsel had the option of projecting a case to cross-examination. If that is not done, in the appellate stage, ifs and buts, how can that be taken as a ground to acquit?
Difficult even
Once
to.
there is a conviction, the trial court has analyzed the evidence. We have to see whether the conclusion is erroneous or not. How can we say that, no, this is okay, but something else could have happened? And therefore we said that can't be that would be erroneous exercise in jurisdiction by the court.
I follow. Has there been a suggestion?
Whatever was there in the, before the court below, how that has been dealt with, that we can examine. But we cannot bring in something which is just not there. That cannot be done in an appellate case, in the appellate forum. So what you are saying is, had this been done, that argument could have been made, and all these are perhaps not relevant now. On the basis of what is there already, you can make an attempt to convince the court. Otherwise, what option do we have? This case lies on a very narrow campus.
Narrow.
Wife found dead, homicidal death is established. Incident happened inside the house. The
In the
daughter
midnight.
implicates the father. He was not found in the place of occurrence. There is evidence to show that he was at home. But immediately after the incident, he was not found at home. Daughter says she saw her running away, him run away.
Prior to that, he was sleeping with the
Prior to that,
deceased.
he was at home, he was seen running away. It was an unearthly hour, 4 AM in the morning.
4, 5 minutes.
There is no allegation that there was a house break, house trespass, or some incident of dacoity or robbery or nothing. And the 2 other persons, daughter has deposed, the son has taken the injured to the hospital. So the chain is complete. What else is required? What else is required to prove? Prosecution need not prove that nobody else tried to kill her. That is not required.
Unless, my lord, of course, unless some doubt was created by the accused.
Sorry, but do you think there is some doubt created?
No, there is no doubt. I have to be fair to the court.
Then what is,
Some doubt, had some doubt been created, my lord, my respectful submission that this lordship could have given him the benefit of the doubt. But here is a case, my lord, other than denial, he offers no explanation.
see, this business of just criminal trial is not a game of chess.
Exactly.
The appellate stage just create some doubt and get
Cannot-
away. That those judgments are not happening in this court. The doubt should be one which is substantive, real,
Exactly.
and taken in the appropriate time in an appropriate manner. Then, which makes it probable that something else might have happened. But a cock and bull story cannot be the basis
At
of
this
the
stage, man.
Hmm.
Whatever story one can build up at the trial stage, my lord, one can do it. Whether the court accepts or not, that is a different issue. But at the appellate stage, bringing in a new story when there is not even a suggestion, my lord, it is difficult on it.
Mr. Decca, we understand your difficulty and your efforts, but tell us, do you think it is a case of acquittal?
No, man. Not in the evidence on the materials on record.
You have to say anything else?
No, my lord.
Lordship, here the witnesses, prime witness is the daughter and the son. Son was reported by the daughter. Lordship, and she also reported the neighbor, next door neighbor, about the same incident. And prior to the incident, your Lordship, this accused person was sleeping with the deceased, my lord. And daughter saw,
Where is the evidence to show that? accused
yes,
was-
evidence of PW3, cross-examination part. On the day of occurrence, I was sleeping in the room of my parents on the floor, and my parents are sleeping in their bed. They were sleeping together, your lordship, and subsequent to that, she saw the accused person running away. There is no possibility that somebody else come in, your lordship, during the wee hours, midnight, my lord, and there is no explanation from the side of the accused. He had not taken the plea of alibi or something like this. Somebody entered into their room.
There is
my
no
lord.
plea of alibi.
Learned, court below has taken into account the evidence of PW3 and 4, your lordship. Para 28 onwards. Should I read, my lord?
No.
No.
You are the amicus here. You are appearing as amicus.
No.
Yes. Yes. Appeal is dismissed.
Second 7. 8. 9. 9.
Yes. Yes, Mr. Das, what is the matter?
I am appearing for the appellant receive as amicus. In this case,
302.
302.
There is an eyewitness here.
There are 9 eyewitnesses. Out of 9 eyewitnesses, the conviction is based only on the basis of the statement of PW2.
PW2 is the eyewitness.
Eyewitness, stated to be the eyewitness. And another significant aspect is lordship. If your lordship is hold that
Let us
yes,
see the Ajahar.
lordship,
Ajahar.
as our page 4. May I read this? Most respectfully, I beg to submit that on 26/2/2016, someone grievously wounded Sabita Raja, a resident of Hatikar village near her own house by hitting her on her head, which resulted in her death at about 9 o'clock in the following day. When police was informed the following day, police came and did the necessary formalities. At first, I thought that my mother had fallen down after getting hit against something and died subsequently. Later, when I inquired about the matter, Biren Nayak's wife, Dipali Nayak, informed me that our neighbor Sri Bittu Praja Elias Motion, son of so had committed the incident. As such, the lodging of the Ajar has got delayed. This is the Ajar. Ajar has been lost after 15 days of the incident.
Yes.
Now, PW1 lordship, Biren Nayak. The deceased Sabita Praja was my aunt. I also know the accused Bitu Praja. This is the appellant. The deceased died about 4 to 5 months back. On the date of incident, I came to my house after doing my job at about 8 p.m. Then my wife, that is PW2, Dipali Nayak, told me that Sabita was assaulted by the accused with brick, and thereafter she was dragged away to the house of the accused. Next day, I verbally informed about the matter in the police station. Next day morning, the deceased succumbed to her injuries. In cross, I did not go to see the deceased after the incident. It is not a fact that I have deposed falsely that my wife, Dipali Nayak, told me that Sabita was assaulted by the accused with brick, and thereafter she was dragged away to the house of the accused. Next, witness lordship PW2, she stated to be the eyewitness. The deceased Sabita was my aunt. I know the accused Bittu Praja. The deceased died nearly 5 months back. On the date of occurrence, in the night at about 6 p.m., the accused assaulted Sabita with brick near our house. I had seen the incident from my house. Thereafter, Sabita was dragged away by the accused to his house. Due to the assault, Sabita sustained injuries on her head and blood was oozing out of her head. Next day morning, I came to know that Sabita died. On the date of incident, in the night at about 8 p.m., my husband came home from his duty, and thereafter I told him about the incident. My husband also did not go to the house of the accused to see the deceased. Police came and seized the brick, which was lying in the front of the house of the accused. In cross portion, my house is at a distance of about 50 feet away from the house of Sabita. The incident occurred in the courtyard of our house. It is a fact that I did not state before the police that incident occurred in the night at about 11:12. At the time of incident, it was dark. 6 p.m. in the month of September, lordship. So there was a darkness. I did not make any hue and cry after the incident. I also did not inform about the incident to the family members of Sabita. It is a fact that I did not state before the police that the accused assaulted the deceased with stone. It is not a fact that I did not state before the police that on the date of occurrence in the night at about 6 p.m., the accused assaulted Sabita with brick near our house. Thereafter, she was dragged away by the accused to his house. Due to the assault, Sabita sustained injuries on her head and blood was oozing out of her head. At the time of occurrence, I was standing outside of my house. It is not a fact that I did not see the incident, and as such, I did not inform about the incident to the family members of the deceased. It is not a fact that as the deceased was my aunt, as such, I have deposed falsely in the court today. Now, further clarification made by the PWT lordship, I am not as, though it is not so relevant, I am not known as Dipali Praja. My name is Dipali Nayak. That's clarification. The case diary may have mentioned me as Dipali Praja, but it is not. It is incorrectly mentioned. Furthermore, no such person known as Dipali Praja is associated with this case. My husband name is Biren Nayak. I am the resident of Hatigarh, Lezinga, under Berikuri, PS. Cross, nothing else. Now, PW3, Dr. Prasanto Buraguhai is the doctor. On 27/2/2016, I was working as SDM and HO at Tinsukia Civil Hospital. On that day, at about 12:45 p.m., I performed postmortem examination on the dead body of Sabita Praja in connection with Berikuri PS GD and so. The dead body was brought and identified by Osim Suikia and Anshu Praja. Anshu Praja is the son of the deceased. On examination, I found as follows. External appearance. An elderly female dead body of average build, shorty in complexion, hair partially gray, 45 cm long, wearing a green blouse, pink petticoat covered by white chadar, eyes and mouth closed, anus and vagina found healthy, blood clot in face and hair present. Rigor mortis partially present. Injuries. And injuries number 1, lacerated injury of size 1.5 cm into 1 cm over the skull on right parietal region and 1.5 cm into 0.5 cm on left occipital region. On this dissection, skull found congested on right front of parietal region and left occipital region. Hematoma on the right temporal region present. Dura found congested, intracerebral hemorrhage on the right side, both vertical and right lateral vertical present. And injury number 2, multiple contusions of small sizes found over the upper part of chest, over back, upper part of thighs of both legs present. On dissection, subcutaneous hemorrhage present. Membranes, liver and spleen congested, bladder full, lyrics, Teresa left lung and right lung congested. Other organs were normal and healthy. Opinion. In my opinion, death was due to coma as a result of intracerebral hemorrhage from head injury number 1, which was antemortem, caused by blunt force impact and consistent with homicidal in nature. Approximate time since death was 24 to 48 hours. Exhibit 1 is the postmortem report and exhibit 2 is my signature. The cross-examination. The head injury number 1 may be caused by falling on a hard substance. This is the only cross. Now, evidence of PW4. Shivani Praja. The deceased Sabita Praja was my sister-in-law. The accused Bittu Praja is my uncle. The deceased died about 1 year back. I have heard that here's a witness. I have heard that the deceased was killed by the accused. I had gone to the house of the deceased. When I heard hue and cry and public also gathered there, I had noticed injury on the backside of the head of the deceased. In cross, I did not state before the police that I had gone to the house of the deceased when I heard hue and cry. I do not remember the name of the person from whom I have heard about the occurrence. Now, PW5, Sri Deepak Praja. The deceased Sabita Praja was my aunt. I know that the accused Bittu Praja, who is my brother in relation. The deceased died about 1 year back. I reached the house of the deceased on hearing hue and cry and came to know that someone had killed the deceased. The assailant used stone to kill the deceased, and stone was lying by the side of the deceased. Here, this is not brick. Here, he said is stone. Police seized the said stone. Exhibit 2 is the scissor list, and Exhibit 2 is my signature. Later on, I came to know from Dipali Nayak that the accused assaulted the deceased with stones. Now, one material, one MR marked as MR number so and so, very good PS, case number so and so is produced in the court today, and the said MR is shown to the witness, and the witness identifies the same as and stated that this is the stone that was seized by the police, which was lying by the side of the dead body. Now, the said MR is marked as material exhibit 1. In cross-examination, I put my signature on exhibit 2 in the police station. I was not read over the contents of exhibit 2, and I do not remember whether anything written in exhibit 2 when I had put my signature therein. I did not state before the police that I came to know from Dipali Nayak that the accused assaulted the deceased with the stone, and that stone was lying by the side of the deceased. The next page. It is not a fact that I have deposed false evidence by stating that I have heard from Dipali Nayak that accused had committed murder of the deceased. The type of stone, like material exhibit 1, is available in open areas of our village. When I first saw the stone, it contained blood stains. The material exhibit 1 presently does not contain any blood stains. It is not a fact that I have deposed false evidence by stating that material exhibit 1 is the stone that was lying by the side of the dead body. Now, PW6, Sri Moju Praja. The deceased Savita Praja was my aunt. I know that accused Bitu Praja, who resides in our locality. The deceased died about 1 year back. I came to know from the villagers that deceased was killed by the accused with a stone. In cross-examination, I do not remember in the name of the person from whom I have heard that Bitu Praja killed the deceased. It is not a fact that I have deposed false evidence by stating that Bitu Praja committed murder of the deceased. Now, the IO also. He is PW7. Name is Navajit Das Bagri. On 26/2/16, I was working at Tinsukia PS as a task officer. On that day, the additional SP headquarters had received an information that a woman was murdered under Veriguri PS. On that day, the OC was absent in the Veriguri PS, and I was directed to conduct the preliminary investigation of the case. Therefore, I went to the Veriguri PS. The GD entry number so and so was already made at the Veriguri PS. It was made by Havildar Dipan Hazarika. Thereafter, I went to the place of occurrence. I had recorded statements of some witnesses. The dead body was lying at the place of occurrence, and I sent that same to Tinsukia PS for conducting inquest. At the place of occurrence, I had seized a stone, which was about 3 kilos. Exhibit 2 is the scissor list, and Exhibit 2 is my signature. Material Exhibit 1 is the said stone. Thereafter, the inquest upon the dead body was conducted, and the dead body was sent for postmortem examination. In this case, I have recorded the statement of Shivani Praja, Dipali Praja, Moju Praja, Deepak Praja, Umesh Praja, and Anshu Praja. That is, she is the informant. He is the informant, Lordship, the son of the deceased. He was not deposed before the court. In cross-examination, on the basis of DD entry number so and so, I had seized the material exhibit 1, and also recorded the statement of the witnesses. The inquest was also done on the basis of the same DD entry, and the dead body was also sent on the basis of the same DD entry. The exact copy of the DD entry number so and so was not in the record. I had prepared a case map of the place of occurrence but this is not available in the case record. In this CD, nothing has been mentioned as to where the dead body was lying. No sketch map is there in the case record. Similarly, nothing has been mentioned as to where the occurrence took place. In exhibit 2, I had not mentioned the exact place of Atigar village where I found the material exhibit 1. In material exhibit 1, I did not take signature of seizure witnesses. The material exhibit 1 was not sent by me to FSL. It is not a fact that material exhibit 1 was not in any way connected to the occurrence. In the CD, the original copy of inquest is not available. Only a photocopy is there. Now, another SI is not an IO. PW8. On 10/3/2006, I was working as an ATAS officer at Beriguri PS. The occurrence took place on 26/2/16. On that day, I was on training at Guwahati. Even the OC late Kusum Ranjan Nath was also absent. Therefore, SI Navajit Das Bagri, the TSI of Tinsukia PS, was looking after the day-to-day affairs of Beriguri PS. After my return from training on 10/3/2016, Ansu Praja had lost an hazard in the police station. In the said hazard, it was alleged that on 26/2/16, someone had caused head injury to Sobhita Praja, for which she died on the next day. The informant has stated that police also came to the place of occurrence. According to the informant, he had come to know from Dipali Nayak that accused Bitu Praja had caused the murder of Sobhita Praja. After receiving that case, I registered a case being Beriguri PS case number so and so, and I took up the investigation of the case. In the Azahar, the informant Ansu Praja has put his thumb impression in my presence. Exhibit 3 is the Azahar, and Exhibit 3(1) is my signature with endorsement. I recorded the statement of Ansu Praja. Ansu Praja was not examined by the court, and Biren Nayak in the police station itself. I also searched for the accused Bitu Praja, but I could not find him. On 11/3/16, I arrested the accused. It may be stated that on 26/2/16, SI Navajit Das Bagri had sent the dead body for postmortem examination. Navajit Das Bagri had recorded the statements of Shivani Praja, Dipali Praja, Maju Praja, Deepak Praja, Umesh Praja, and Ansu Praja. After lodging of the Azhar, I again recorded the statement of Ansu Praja, and on 14/4/16, I recorded the statement of Dipali Nayak, wife of Biren Nayak. In the meantime, I got transferred, and as such, I handed over the CD to the OC. In Cross, the place of occurrence is situated at a distance of about 6-7 kilometers from the Beriguri PS, but the Azhar was lost after about 15 days of the occurrence. In the Azhar, there is no endorsement to the effect as to who took the LTI of Ansu Praja. It is not a fact that the exhibit 3 was not filed by Ansu Praja. It is not a fact that the witness Dipali Nayak did not state before me that on the day of occurrence at about 6 p.m. the accused assaulted Sabita with a brick. It is not a fact that she also did not state before me that after the incident, Sabita was dragged away by the accused to his house. It is further not a fact that the witness Dipali never stated before me that due to assault, Sabita sustained injuries on her head and blood was oozing out of her head. Now, the last witness, PW9, Sri SI Nikunja Burman. On 36/2016, I was working at Beriguri PS as OC. On that day, I had received the CD of this case from SI Chandan Das. On perusal of the CD, I found that there was nothing to be investigated because the investigation was already complete. Therefore, on the basis of the material available in the CD, I had filed a charge sheet under section 302 of the IPC. Exhibit 4 is the charge sheet and Exhibit 4(1) is my signature thereon. In cross, it is not a fact that without properly going through the study, I had unnecessarily filed the charge sheet. Now, page number 23, Lordship, T13 statement. This is most important in this case. Only 3 questions were put to the accused, Lordship. Question number 1, though it is not marked as number 1, 2. Witness Dipali Nayak has first question.
So it's a case of denial. Only 3 questions have been put.
But may I like to point out one vital aspect. Here only 3 questions and no opportunity was offered to the accused person to adduce any evidence before the trial court. It is not totally absent, Lordship. And this honorable court, by your Lordship judgment, if your Lordship permit, I will produce later on. Here, that part is totally absent. That opportunity was, if your Lordship is convinced that yes, he has committed the crime, then that part is, without that part, trial may be vitiated. That is my only humble submission. Lordship, kindly come to T13 statement. Here, look into it.
313.
313, may I read
Yes,
one?
requirement is that all the circumstances has to be put, but he has to show what prejudice is caused to him. The 3 questions that were posed, of course, were very small. I've seen. All the witnesses, statement of all the witnesses were not put to him. But what prejudice is being caused to him? Of course, the recovery of the body and the stone, and the PW2 said he was dragged to the house of the accused, but the body was ultimately found at the place of the deceased only.
And he also says that no opportunity was, he was not asked whether he wants to adduce evidence.
That perhaps that questions are also so difficult to read here.
No, here,
Why don't you just examine it? We can
Huh.
take it up again on Wednesday and conclude it.
Of course, putting the question whether you want to put something in a defense, that is a mandatory part.
that one first question, Lordship, may I like to draw your Lordship attention. Suppose that you hit your wife, Sobita, on her head. She is not the wife of the. It is also incorrect.
It's a neighbor, wife of
She is
the.
not the wife.
Hmm.
Incorrect question has been put to the accused.
Just examine it. And
Not
we'll deliver the judgment on Wednesday.
Uh,
Give him the copy of the judgment, reference number, which you want to rely.
No, Lordship, I have a copy right now. I have a copy of this.
Yes, just give me the citation.
Right now, I will place your Lordship.
I'll just take the party's name, Sahid Khan,
Yes.
Lordship. I've taken it, I'll see.
Another Supreme Court decision.
Prakash Tiwari, Lordship.
You
If
have
it-
extra copies, can you pass on extra?
Yes.
Yeah, I have extra copy. I have for your Lordship. I have already. Two judgment, one judgment from Supreme Court, another. This.
Your Lordship's judgment, where I was also there.
Though this.
Go through these judgments minutely and see what happens.
May.
Apparently, on the face of it, it seems some prejudice is there. So in that case, remand will be the only.
Should
option.
I give the paragraph number, Lordship?
Huh.
In the first case, Mohammed Said Khan. In 2018. Paragraph number 16, 17, 18, and 22. And next case, Lordship, Joy Prakash Tewari in criminal appeal number 704 of 2018, passed by the Honorable Supreme Court. Paragraph number 19, 20, 25, 26, 27, 28, 29, and 30.
All right, We'll take it up again Wednesday.
On Wednesday.
You examine the judgments in the light of this and make it.
Yes.
Any other matter? Anybody ready? Anybody else ready for hearing part two?
No, they are not for part two matters.
Then,
Some other matters.
I have no case for hearing. Today I have no case.
you have no case.